by placing excessive emphasis, I apologize, on Mr. Zapata's probation performance at his resentencing on revocation of probation to the exclusion of a sufficient consideration of the original offense. Second, whether the trial court improperly abandoned its discretion to sentence to probation when it repeatedly stated that it would not consider probation sentences on resentencing. I intend to focus my argument on issue 1, but I am of course happy to answer any questions this court may have on issue 2.
Well, I have a question to start with. All three of us on this panel have been trial judges. Is it permissible for the judge to talk about behavior on probation as a way of explaining why probation wouldn't be a good sentence to reimpose?
Absolutely, Your Honor. And this court in People versus Young made the standard very clear. A court may consider probation performance for its effect on rehabilitative potential, but the sentence must in fact be for the original offense and not for the sentence on probation. In this case, the evidence at the sentencing hearing and at the motion to reconsider suggests that the sentence was in fact for the probation performance and not for the original offense. The court here focused its discussion at the sentencing hearing.
Counsel, you say it suggests. What are we to presume at this stage of the proceeding?
Your Honor, this court is to presume that the trial court understands and follows the law. However, the evidence in this case points squarely in the opposite direction. The court here specifically stated that it was focused on the performance on probation as an antecedent for increased punishment.
Where did it say that?
I apologize, Your Honor. I'm pulling up my list of quotes now, but the court stated at the sentencing hearing that there needed to be a consequence. It stated, and this goes back to Attorney Meeson's statements, there needs to be a consequence for something. And so the court's framing is that there is a relationship between probation performance as the cause and the punishment, the increased prison sentence, as the effect. That is the court's understanding. It further said at the same hearing that this is the sort of thing that Mr. Zapata should have been afraid of. And so again, what the court's doing there is it's looking to the original offense, not as, I apologize, it's looking to probation performance, not as providing additional context for the original offense, but rather as being itself the cause for increased punishment.
Let me ask you a question. Let's assume for the moment that the judge perhaps did talk more about performance on probation than he needed to or should have. What about the fact that your client has a miserable record and it was a terrible crime? Doesn't that counterbalance any extra emphasis the court put on his miserable performance on probation?
Your Honor, the court was certainly permitted to consider the bad probation performance in this case as evidence.
No, I didn't ask that. I said, isn't that, assuming that it occurred, isn't that more than counterbalanced by the fact that he was lucky he got probation the first time, that it was a terrible crime that could have caused untold damage and harm, and 3, he had a miserable record?
No, Your Honor. This court has consistently held for more than 4 decades that the sentence on resentencing must in fact be for the original offense and not for the conduct on probation. That's consistent with the other districts. The 2nd District in People versus Varghese and the 1st District in People versus Gorge have similarly held.
So you cite Varghese. Varghese has been frequently criticized, including by this court on multiple occasions. But there is a distinction, is there not, in that in Varghese, the probation violation is based upon a separate criminal offense. And in that situation, you've got a clear due process concern if a court is not clear in how it's imposing its sentence, that it may be in fact sentencing the defendant for the either uncharged or unconvicted offense that's the basis for the probation violation. And then that's distinguishable from a situation where a defendant is before the court on a technical probation violation, where the only offense for which he could be convicted would be or be resentenced is the original offense. We talked about that in People versus Yarber, and we pointed out that even Varghese, which is a 2-1 decision, included a lengthy dissent by Justice Burke, and Justice Burke quotes, I think in a block quote, a significant portion of Young, pointing out that we're not supposed to take a head in the sand approach and just look at the specific words of the court at the time of resentencing, but we're supposed to look at everything that the court would have had available to it and would have known about the case from its outset. Do you agree with all that at this point?
I agree with just about everything, Your Honor. I agree that this
Okay.
court has much.
You agree that this court spent a great deal of time at the original sentencing. In fact, at the time of the plea, the court itself was the one who recommended that the defendant be given additional time between the plea and the sentencing in order to maybe show better performance on probation, correct?
Your Honor, Mr. Zapata was not yet on probation at that point, but the court did intend in a
Right, but it said it wanted to give him time to be able to determine whether he was going to be able to perform on probation, did it not?
Yes, Your Honor.
Okay, and at the time of resentencing, the court actually even waited after hearing the arguments till the next day to impose the sentence and made it very clear to Mr. Zapata that based upon his 20-year criminal history, his terrible performance on probations as it already existed, that it was very much on the fence as to whether he should even be considered for probation, but that it gave him probation because it thought that maybe probation was actually a harder sentence for him at that point than a 4-year sentence with credit for time served. So he was given a warning at that time, basically, as Justice Connect pointed out, look, you probably should be going to the penitentiary, but I'm going to give you one more shot and don't blow it. Isn't that basically how that sentencing went?
That's more or less what the court understood itself to be doing. Yes, Your
Okay.
Honor.
So what's wrong with that? Anything?
Yes, Your Honor. On resentencing, the court is to consider the original offense. The court here considered the probation performance. That is the critical.
The court recited the indictment.
Yes, Your Honor. And while a court reciting an indictment is some evidence that the court at least thought about the original offense, when that evidence is overwhelmed by evidence that the probation performance was central to the decision, that will be what this court holds in accordance with.
Well, the court even said at the time of the sentencing that it was basing its decision on the arguments of counsel, the pre-sentence report, reviewing the entire pre-sentence investigation. And the court had pointed out, it's been the judge in this case this entire time. It was very familiar with Mr. Zapata. It was very familiar with the facts of the case. It was very familiar with his performance or lack thereof at the time of imposing the sentence. When he came back for resentencing, we even got an opportunity to have the court explain to us again what exactly its rationale was. And in there, it said that the miserable performance he had discussed at the original sentencing has nothing to do really with any of the factors in aggravation and any of the factors in mitigation. It had to do with an opportunity to complete a probation sentence. So isn't that exactly the situation that we talk about frequently? The courts commented on the performance on probation as an explanation for why, no, there's no possibility that Mr. Zapata is about to be considered for probation again.
Your Honor, the court here suggests that what it is doing is considering the probation performance as its principal consideration. It said, quote, the reason for my thinking on that being the appropriate sentence, quote, was the fact that he,
Page, please.
apologize,
Page, please.
that's the end of record page 532 and on to page 533. The reason for my thinking on that being the appropriate sentence, quote, was the fact that he had literally had accomplished almost nothing. And this was not tangential. The court stated that the reason for the increase, this is on page 533, was, quote, mainly for those reasons. He did nothing on probation, he made no effort at getting anything done on probation, and he stayed on probation. I would point this court's attention to its recent unpublished decision in People versus Gans, in which this court reversed on one of these issues, on improper consideration of probation performance, in a case with nearly identical facts to this case. There, this court was greatly concerned with the trial court's statement that the probation performance was the most aggravating factor.
In Gantz, the trial court explicitly said that the level of the criminality that has taken place since the defendant has pleaded guilty was the most disturbing or most aggravating factor it was considered.
Yes, Your Honor. And here the court said that its increase in sentence was mainly for those reasons. He did nothing on probation. It said that the reason for its thinking on the increase in sentence was the probation performance.
Well, in reality, if you read the entire, see, there's the problem when you parse out the language like that, you can make it sound like it says anything you want to argue it. In reality, he begins talking about, so if the question is, why did I impose a 7-year sentence? And that's how he's explaining what he's doing. Why did I impose a 7-year sentence? I didn't even think about the issue of extended term candidly. I was listening to both sides arguing about it, and the state was asking me for to sentence him to 10 years. You were asking me to sentence him to 5. But the reason for my thinking on that fact, that he literally had accomplished nothing. So there's no way he's going to be getting a probation sentence, because wasn't the original request probation, and if not probation, 4 years?
Yes, Your Honor.
Okay.
Go
ahead. I'm sorry.
I would point to what's perhaps the single clearest indicator of what the court understood itself to be doing here. This is the very last thing the court says before affirming its sentence at the motion to reconsider. This is on record page 533. The court's considering the idea that Mr. Zapata needs to be around for his children. And it says that, quote, he should have thought of that when he got on his probation sentence in June of 2023. What's so critical about that statement is what it's not saying. The court is not saying Mr. Zapata should have thought about his need to be there for his children when he committed the crime of arson. It's saying that he should have thought about that before violating his probation. And that's what everything is tied back to for the court. For this court, everything tied back ultimately to the probation performance. And that goes back to exactly what the court said at the initial resentencing hearing. It discussed this as a consequence. It said in the same language that Mr. Zapata should have been afraid and should have complied with his probation for that reason. And so what the court's doing—
Well, I would suggest to you that goes back to the initial series of questions you were asked. It was clear that this defendant was clearly a candidate for prison. The court was giving him one last shot. And I would suggest to you that the language you have interpreted as you have at the motion to reconsider is in reality its explanation for how it came up with 7 years. 7 years was because the state had asked for 10, the defendant had asked for 5. Since he was going to be going to prison, he basically split the difference and gave him 7.
Your Honor, the court is required ultimately to sentence for the original offense. Here, that's not what the court's focus was. It stated that repeatedly. What's unique about this case, among cases where an excessive focus on probation performance is alleged, is that the issue is preserved. That's very rare in this sort of case. In People versus Gans, the issue is not preserved. This court considered it as plain error. And what's so important about preservation, what's so essential about the preservation doctrine, is that it means that the trial court had an opportunity to pass on this issue. In People versus Young, this court took the opportunity to clarify the prior law, which it felt set a trap for trial judges, that they would say the wrong thing and have cases reversed. In this case, the court had the opportunity to clarify that Mr. Zapata alleged in his post-sentence motion, in his motion for reconsideration of sentence, that the court had excessively focused on probation to the exclusion of a sufficient focus on the original offense. The court was aware that that concern was present, and it was given the opportunity to clarify its statement and say, no, this sentence was for the original offense. It was not made for probation performance, but it did quite the opposite. It stated that the reason for its thinking was the probation performance. It couched its language in Mr. Zapata needing to be afraid of a prison sentence as the result of poor probation performance. In the context in which the motion to reconsider is occurring, the court was aware that there was this concern present that it had excessively focused on probation performance. It had ample opportunity to clarify its language and make certain that its words were not interpreted that way, and it did exactly the opposite. And so I would just, again, call back to this court's law in People versus Young, more than 40 years of precedent, that the sentence must be for the original offense and not for the probation performance. I would note that in this case, the court focused its language on a cause-effect consequential relationship between the probation performance and the increased sentence. And I would note that the court was given a significant opportunity to clarify its language, and it chose instead to double down. For those reasons, Your Honors, Mr. Zapata respectfully requests that this court reverse the ruling of the lower court and remand for a new sentencing hearing. Thank you.
Thank you, counsel. The appellee.
May it please the court. Good afternoon. My name is Jessica Theodoratos, and I represent the people. Turning to the first issue, the trial court did not abuse its discretion in considering defendant's poor probation performance in sentencing him. The manner in which a defendant conducts himself on probation is an appropriate consideration in any sentencing hearing. A sentencing court may consider the defendant's behavior while on probation to the extent that it evidences his rehabilitative potential. It is true that the trial court stated at the motion to reduce hearing that defendant's miserable performance had nothing to do with the factors, but the remarks of the trial court at sentencing must be taken in context, read in their entirety, and including the arguments of the parties and the fact that defendant committed the serious crime of arson. At sentencing, the people argued factors in aggravation applied, including the nature of the offense being severe and set fire in a gas station next to gasoline, and he took time to put together papers and cardboard after barricading himself in an office. The people argued defendant had a history of prior criminality, and the sentence was necessary to deter others. The trial court referenced the original offense immediately before sentencing defendant and stated defendant committed the offense of arson against a gas station, which damaged it. The trial court also considered the arguments of counsel and the picture and surveillance footage from the offense, and these excerpts from the sentencing hearing show that defendant was sentenced for the original offense of arson. To the extent that the trial court considered defendant's conduct on probation, it did so as it related to defendant's conduct up until sentencing, which was a clear showing of his lack of rehabilitative potential. The judge discussed at length the ways defendant violated probation, but he was not sentenced for the mere fact that he violated probation. It needed to be noted what happened went beyond a typical violation of probation, and the trial court discussed all the ways which defendant did not comply. This goes towards the factors the trial court was considering in determining whether prison was appropriate. And given defendant's performance, it was clear defendant had no interest in complying with probation requirements and should not get another chance at probation. It's also relevant that defendant did not get the maximum sentence nor the 10-year sentence the people requested. The judge put thought into the sentence. The trial court later stated at the motion to reduce sentence hearing that defendant's miserable performance had nothing to do with the factors, which was simply a comment on defendant's probation performance and why another term of probation was not appropriate. This remark alone does not negate the rest of the record, which shows the trial court was providing information regarding defendant's poor performance and did consider the statutory factors in aggravation and mitigation alongside with the probation performance. And at that hearing, defense counsel and the people both argued that the trial court could not use his probation performance as a penalty and he needed to be punished for his underlying offense. Case law provides that in considering a defendant's poor performance on probation, it may impose a harsher sentence on defendant specifically because of that conduct. When a defendant has violated probation, he stands in a different position before the trial court than he did at his original sentencing hearing, and this justifies the imposition of a longer sentence. Ultimately, a court may sentence a defendant to a lengthier sentence due to poor conduct on probation, and this does not inherently suggest the court is imposing the sentence as punishment for the defendant's probationary conduct. The record, when taken as a whole, clarifies that the trial court specifically stated it considered the pre-sentence investigation report and described defendant's arson offense. The trial court commented on the factors in aggravation and mitigation. The record here should not persuade this court to find that the trial court in fact intended its sentence to act as a penalty for defendant's conduct on probation. I've got a bit of time left, so I'm going to address the second issue. I just want to briefly touch on the fact that the trial court did not abuse its discretion in restricting the possible sentence to exclude probation. When defendant was initially sentenced, he was warned that if he violated probation, he would likely be sentenced to a term of over 4 years in prison. It is proper for the trial court to give the defendant notice he will not consider probation again if a petition to revoke is filed against the defendant. The trial court may not categorically refuse probation based on the type of crime the defendant committed, but it can put the defendant on notice that it will not consider probation if a petition to revoke is filed.
Counsel, at what point do those warnings about probation cross the line and become evidence of the judge's improper predisposition against probation?
I think we need to look at each case contextually as a whole. What was the initial crime committed? What type of violations were occurring? I think it's fact specific, Your Honor.
And does it matter at all in this case that neither the state nor the defendant in their sentencing recommendations asked for probation and both sides asked for or recommended a prison sentence?
Absolutely. This would fall under, I believe, the case where defendant invited the error. Therefore, he seeks plain error review of this issue, so therefore it would be inapplicable. Defense counsel argued that he should be sentenced to 5 years in the Illinois Department of Corrections, and he made no argument that he should be sentenced to probation. And plain error analysis applies to cases involving procedural default and not affirmative acquiescence. But if this court were to find no acquiescence occurred, the evidence at the sentencing hearing was still not closely balanced. There was no error committed because the trial court properly found that probation was not appropriate for defendant given his poor probation performance, and it was not based on the type of crime defendant committed. Furthermore, the evidence at the sentencing hearing was not closely balanced. The defendant had an extensive criminal history, including a conviction for aggravated criminal sexual abuse. Defendant risked serious harm by committing arson at a gas station where explosive chemicals were present, and there was little by way of mitigation evidence presented except for defendant having 4 children. The evidence was not closely balanced that he would have been sentenced to probation absent the error complained of. Defendant also contends that trial counsel was ineffective for failing to object to the trial court's exclusion of probation sentences, but trial counsel's performance was not objectively unreasonable because trial counsel had little to no argument to make that defendant should have been sentenced to probation. Defendant clearly violated probation in numerous ways after being warned that probation would not be available to him if he violated. Therefore, it was not objectively unreasonable for trial counsel to seek a sentence of 5 years instead of asking for probation. As defendant even notes in his reply, defendant could have preferred a 5-year sentence given he had extensive credits to apply towards it and he had previously been unsuccessful on probation. Therefore, it was not objectively unreasonable to seek a sentence of 5 years. But ultimately, the trial court did not have a predisposition against probation based on the class of crime defendant committed, and an objection on that basis would have been meritless. But second, the record here is clear that even if the complaint of error amounted to an objectively unreasonable performance, the outcome of the proceedings would not have been different. The record is clear from the sentencing hearing that probation was not an appropriate option for a defendant, given his poor performance on probation, and trial counsel would have been unsuccessful seeking a probation sentence. The trial court warned defendant that if he violated probation, it would sentence him to a prison sentence. A reasonable probability that the outcome would have been different does not exist here. Are there any questions I may answer at this time?
I see no questions.
Thank you. That'll conclude my time.
Thank you, counsel. Rebuttal?
Thank you, Your Honor. Two brief points. First, the state relies heavily on the state's argument in favor of an increased sentence at resentencing. The state went into a great deal the state had a great deal of focus on the original offense, on the permissible statutory aggravating factors. I would note that the court did not make substantial reference to those initial factors. The court is focusing its attention on the probation performance, notwithstanding the state's argument. And so when the court is given all of these things to provide an object for its discussion, and it instead chooses to focus on the probation performance, and when it further states that the reason for its thinking is the probation performance, that the main reason for the increased sentence is the probation performance, that is evidence that the court, even when provided with potentially aggravating evidence that the state argued was aggravating, nevertheless focused its attention on the probation performance. Second, I would just note, there's reference to the fact that the trial court in this case read the indictment, acknowledged the existence of the pre-sentence report. This court in People v. Gans was faced with similar facts. There, the trial court expressly considered the pre-sentence investigation report. The trial court expressly considered a long and violent criminal history.
We've already pointed out the differences in the specific statements that the court made. That it was the actions on probation that were the aggravating factor upon which the court was imposing its sentence. That takes it out of this realm entirely.
Your Honor, the court's statement here that the main reason for its thinking was the probation performance is similar.
I would suggest once again that that's been taken out of context, and I read to you the full context. It had to do with the difference between the two sentences being argued by the state and by the defense. You also seem to ignore the fact that the court was well aware, as it pointed out at both the resentencing and I believe the motion to reconsider, that the defendant had dodged a Class X felony mandatory penitentiary sentence only by the good graces of the offer by the state. He was on video. He was on video committing a Class X aggravated arson at a gas station. They dropped that charge and let him plead to the probationable offense so that he could at least argue for probation. All of this was known to the court at the time of resentencing and at the time of the motion to reconsider. I get it from you that he's supposed to go back through all of the factors in aggravation and mitigation again and use some sort of magic language in order to avoid this sort of an issue being raised.
Your Honor, I want to note the court is absolutely not required to state any magic words. The court is absolutely not required to enumerate the factors in aggravation and mitigation. The court merely is required to issue a sentence that is for the original offense and not for the probation performance. The court's language here indicates the contrary. For these reasons, Your Honors, Mr. Zapata respectfully requests that this court reverse the ruling of the lower court and remand for a new sentencing hearing. Thank you.
Thank you, counsel, for your arguments. We'll take this matter under advisement and wait the readiness of the next case.